Juanita, if a tenant is harassing another tenant on your property, even after complaints from the tenant and warning from the landlord, the other tenants don't stop the harassment and it's getting physical, can a landlord ask them to vacate with immediate effect?
Probably not. It depends on how far the harassment goes. If it is a loud tenant, and if it's getting physical, is sort of somebody walked past the one on in the parking lot and shouldered him a little. It is in fact a criminal offense. That in its own is what's the crime I'm looking for? Assault. Thank you.
I was like, wait, it must be something I don't know.
Look at us being property lawyers and not criminal guys. Assault. So assault is a very wide crime. Even if you spit on somebody, it does probably fulfill the elements of the crime of assault. And if your lease agreement does allow for a situation where the landlord can cancel the lease agreement with immediate effect, in a situation where the tenant is guilty of a crime or committing a crime or suspected of committing a crime, and there is a provision where this crime must be reported to the police, there is actually good prospects of cancelling that agreement with immediate effect. And why I'm saying good prospects and not sure out law is if somebody is cooking crystal meth in your kitchen, or if somebody is using the rental property as a brothel, or if they are actually assaulting the neighbors, if you cancel the agreement on that basis, the chances of them coming to court fighting the lease agreement cancellation is slim to none. But in terms of Section 14 of the CPA, in fact, you do need to give somebody 20 business days to remedy their breach. The reason why we make an exclusion on crimes is it could be a very risky situation. Say somebody is cooking meth or selling drugs from the property. You could be, as the landlord, potentially at risk, and you can't condone crimes, but we can't make crimes up and say, this is why I'm cancelling the agreement, because I don't like my tenant, so I am saying he's selling drugs. Meanwhile, back at the ranch, it's actually a Herbalife person. I'm sorry, respect to Herbalife people, but he's actually selling Herbalife, and it's not in fact the drugs that you're thinking it is. It's actually a bona fide sort of side hustle that this person is having. So be careful of that. I must say, in a situation like this, if it's in a body corporate, in a sectional title, I would ask for the body corporate's assistance in this by fining the tenant for this behavior. If it's not in a sectional title complex, I would call the police at the next incident. Get the police out to come and resolve the situation. Place the tenant on terms. Give him another 20 business days to get his stuff in order. And make sure that letter of demand is actually done by a specialist rental firm. Because if you word it correctly, you could then, at the next instance where this person gets harassing, that's a legal term, cancel the agreement with immediate effect. But be careful of immediate cancellation. If it is something that's serious enough to require immediate cancellation, you might get away with it. But don't cowboy this one. Rather, pick up the phone, chat to Bruno's firm, my firm, and get the right answer on that, because the facts and the specific facts in this matter is more relevant than just a quick answer.